Okay, so before starting chapter 5 and finishing tort law, as we're going to finish today, just review some concepts from Monday. Brief review on intentional torts. Well, first of all, what is the main objective of tort law? To just didn't understand again.
Remedy a wrongdoing.
Okay, yes, to remedy wrongdoing. What is the main remedy parties will seek? Monetary compensation or damages. Yes. So one of the main purposes is to seek compensation or to provide compensation remedy to the parties when a wrongdoer acts in a wrongful way. So we saw it's a social wrongdoing. Is tort a tortious conduct? Is it the same as a criminal offense?
Not necessarily.
Exactly, not necessarily. Well, actually, a criminal offense is one thing, a tortious conduct is another thing. Sometimes the single conduct may classify as both, such as theft or conversion. But you all remember from our first week that a tort is dealt with in private courts, in a lawsuit. And a criminal offense is dealt in a criminal proceeding by prosecutor. And we also saw breach of contract. Just to differentiate, breach of contract is not necessarily wrong, but it is when an obligation in a contract is not complied with or not complied with in a satisfactory way. So it's not a breach. Right. I told you we have intentional torts and unintentional torts. So many of the torts we saw on Wednesday, they are intentional torts, where the intention is related to the conduct, not the harm itself. So we went through trespass to person, remember assault and battery? What is the main difference between the two?
Assault is the threat of harm, while battery is actual harm.
Yes, so in a battery, there's actually the unwanted physical contact. And in assault, you're just about to be struck. You're threatened to be struck, but you were not. Two main defenses. Do you remember the two main defenses? Consent, voluntary or informed, very good. And also self-defense, yes. Is self-defense unlimited, or is there a limit to self-defend oneself?
Should not exceed the force that it's used in. So
Yes, so no excessive force. It has to be reasonable. Whether the conduct while self-defending yourself was reasonable or not, this is going to be a question of fact or a question of law. What do you think? Question of law or fact? Law, yes. So question of law, whether it was reasonable or not. Right. Then we saw trespass to land, someone else's property, being there without authorization, or even if we throw garbage boxes, things. Only defense is if you've landed there accidentally, or if there was consent for you to be there. Then we saw torts related to chattels. Chattels, they mean the same as goods. So trespass to chattels. A trespass to chattel is when our goods are interfered with, when our goods are damaged. And then we have also conversion. Conversion is illegal appropriation of someone else's goods. In other words, conversion is the tort and theft is the criminal offense. They are the same thing, but in different legal areas. And then that new, you remember that new? So the word that new related to detention, that new, what is that new?
Retention of the borrowed object.
Yes, so when you retain, when your intention is to retain goods that were legally given to you or lent to you, but you illegally retain them, you detain them, you don't want to return them. So that's that new. And then we saw false imprisonment. When I give you an example, when does false imprisonment most likely happen? Or where? Shopping malls, shopping centers, grocery stores, department stores. So it's usually, not only, but usually, there may be a suspicion of shoplifting, and security guards or any other employees, they will try to search the alleged shoplifter. We also saw malicious prosecution. So when the justice system is used to do bad to someone out of malice. What else? We saw defamation. Oh, before defamation, nuisance. Remember nuisance? What is nuisance?
Neighbors.
Yeah, so interference with our right to enjoy our property. So if a neighbor, if someone nearby is interfering, remember the swimming pool example, someone flying drones or ashes from fire, even smoke, could be pollution. So those are examples of private nuisance. And then defamation. Defamation usually false statement, but statement can also be true but detrimental. And then there's going to be slander. So S, slander, spoken. There's usually no record, no permanent record is left. So you need witnesses reporting. And there's libel. Libel is usually when it's written or published. But those are, these two are still defamation. And then defamation has to be the false statement, or that statement has to be published, but published in a broad sense, spoken out. If it's only you and I in a room and I call you as a drug dealer, it's not defamation. You may be mad at me, whatever, but it's not defamation. But if someone else hears, or if I publish, then it may be defamation. Defenses, I'll just list them. So truth, if the statement, the alleged defamatory statement is, as a defense, is said to be true or false. If you prove it's true as a defendant, then you get away from the defamation lawsuit. And then there's two types of privileges, absolute and qualified privileges. And then fair comment, criticism, and responsible public interest responsible journalism. So this defense was created by the Supreme Court of Canada. So if needed to, you may want to review those defenses. And then one concept we looked at before talking about all those torts was also vicarious liability. Do you know what vicarious liability is? Or do you remember?
An employee makes a tort, and just by the vicarious liability, the employer is held guilty as well.
Yes. So when one who is not at fault is also liable for the tortious conduct of another. So that's the example. Best example is this: employer and employee. The employee acted wrongfully, but the employer is also liable. As long as the employee acted wrongfully while performing their job duties. If the employee had acted wrongfully out of the scope of work, then the employer has nothing to do with it. So that's vicarious liability. And then there was a list of some torts that impact business in the end of the chapter. So some intimidation, infliction of mental suffering, deceit, passing off, misuse of confidential information. What else? I'm forgetting one here. And then we also looked at the privacy torts. So many invasion of privacy. It can be online, but can also be physical. And there was a new tort we saw, intrusion upon seclusion. This was recognized by the Court of Ontario as of now. And I also told you, not in the slides, but I told you that last year, the Alberta courts, they recognized the revenge porn tort. Okay, and many other torts may be recognized as society evolves. So those were mainly business torts and intentional torts. Today, we're going to look at the unintentional tort. Then we'll move to several types of liability, such as professional liability, product liability, strict liability, occupier's liability. So there are several situations in which a person may be liable if another is injured or suffers a loss. And we will end by looking at insurance. So the type of tort that we're going to look at today is the most important one. And when I say the most important one, I mean this is the one that is more litigated. Because actually, most losses, damages, injuries that are caused in real life, they are not out of intentional conduct, but they happen because of careless conduct, unintentional conduct. Again, I think I told you on Monday, I'll repeat. Most car accidents, are they intentional? No, they are out of careless. They are out of unintentional conduct. Driver was texting and driving, was over the speed limit, didn't pay attention to the traffic lights, whatever. Okay, so that's why this tort is known as negligence, unintentional tort, is the most litigated one. So the one we have to be more careful about. So what is negligence? It is conduct that is either careless or unintentional, and that conduct causes injury or damage or loss to property. So there's a damage in this careless conduct, damage either to person or to their property. I told you that in the intentional torts, damage is not required. So if I threaten to throw this at you and you feel threatened to be struck by my clicker, you were a victim of assault, regardless of the damage you suffered or not. But here, for the unintentional tort, the negligence, damage, or injury or loss is required. Maybe, who has a car here? Anyone? Okay, so you have probably, I hope you haven't done this many times, but you have probably texted and driven at the same time. But you have not caused any damage to anyone. So you were negligent, but there was no negligence tort against you because you caused no damages. Okay, so here for negligence, a damage is required. This is very important. A damage is required. And when I say damage, I also mean injury. Okay, when I say damage, I mean either loss to person or loss to property. Okay, and then for a negligence tort to be successful, not only damage has to be there, but also breach of a duty of care and causation and the link between the conduct and the damage caused. So in other words, A, B, C, D are required in a negligence tort. A, duty of care, breach of that duty, causation, which is the link between the breach and the damage itself. Okay, so 4 ingredients are required, and we're going to go through all these four. And we start with a duty of care. So whenever a court or whenever we, after an event, after a damage, if we want to know if we are liable for that or not, we have to go through what is called reasonable foreseeability test. This is a simple test. The test says, is it foreseeable that loss or damage may be caused to anyone or to any property by doing what I'm doing? That's a simple question. So driving, when you are driving, is it foreseeable that you may cause damage to your passenger? Yes. To pedestrians? To other drivers? To property in general? So, if the answer is yes, then a duty of care is owned. But we don't need to be much worried about this requirement. Why? Because throughout history, courts have already recognized that many relationships in the world, many real relationships, in many relationships, a duty of care is owned. So we don't need to debate about this. Defendants in a negligence lawsuit, they will rarely challenge this requirement. So I'm suing you, or you are suing me because I caused you loss. In my defense, I may raise that I did not breach the duty, or there was no damage, or the damage that you suffered was not directly linked to the breach of duty. But I will usually not debate or challenge that a duty of care was owned. Because in many situations, in most situations actually, a duty of care is owned. Is it foreseeable that by lecturing here to you, I may cause you losses, injuries? Yes or no? No? So what if I throw this at you? No, see, your point is valid, but what I'm trying to convey is that in most situations, just by living, by doing what we do, it may be foreseeable that loss, injury, damage may be caused to others. What if I'm just walking here? You see, as an Italian citizen as well, I speak with my hands, and then accidentally I hit the screen of your laptop. That was careless, unintentional. Was it foreseeable that I could have caused you damage? Yes, not desirable, but foreseeable, yes. Right? Another example, one I like to use commonly, projector. So let's say I'm a technician. So I need to fix this. Is it foreseeable that by fixing this or trying to fix this, I may cause damage, loss to others, to people in the classroom? Yes. Could be even related to electricity, could burn out your devices. So yes, a duty is owned. So in most relationships, if not all, a duty is owned. Okay, so that's why this first required element is not so challenged. But if needed be, if there's a new relationship, a new situation, what will courts do? They will apply the reasonable foreseeability test, the one I exemplified to you. I'll be back here for misfeasance and nonfeasance. Now I'll come to the second requirement. Breach of standard of care. Well, if in most situations a duty is owned, then if I act below the standard of care, it means I have breached that duty. So let's say I'm a cleaner, I'm mopping the floor. What would a reasonable person do to avoid others to slip and fall? Put a sign, and even ask people not to walk in the slippery floor. So this is the standard of care. If I act below this standard, I have breached my duty. Does it make sense? Let's come back to the projector. What would a reasonable, and I'm talking about the reasonable person test. So what would a reasonable, prudent technician do before starting to fix the projector here? Clear the classroom. Ask people to move away, leave, sit far away. If I don't do this, I have breached my duty because I acted below, right? So remember, I'm trying to establish the 4 ingredients. The first one is usually there. Then I need to debate about the second. Have I acted below the standard of care or not? Because if I have not acted below the standard of care, I have not breached it, even though I may have caused you loss, right? So that's the breach of the duty. The test that is applied is the reasonable person test, as I have just explained. What else? We're going to talk about experts in a minute. So before, okay, reasonable person. Who is the reasonable person? A reasonable person is not a perfect person, not an average person, is a person that is more similar to the situation. So here, with a technician that may have breached the duty, I would compare to the conduct of another technician. Okay, so it's a little over the average, but it's not an average person. It's not 81. It's most similar to the situation as possible. And no perfection is required. Now, before we move into the causation and damage, let's look at those 2 concepts, misfeasance and nonfeasance. Well, what is misfeasance? Misfeasance is the act that causes harm. It's the wrongdoing. It's acting wrongfully. That's misfeasance. And when there's misfeasance, the courts have a remedy. So the victim may sue for compensation. Again, if I were texting and driving and I hit someone, caused them loss, I acted wrongfully and I caused harm to another. So misfeasance, courts will offer a remedy. But the opposite of misfeasance will be nonfeasance. Nonfeasance is our failure to act. Failure to act means there's someone drowning in the swimming pool, and I am there, lying in the sun. If I fail to save that person, I am not liable. Why? Because the law does not require me to act. Right? And when I don't act, it means I fail to act. But I am not required. So that's why nonfeasance will not be remedied by the courts, because we're not required to. Even a doctor, let's say a doctor is driving on the road, they see an accident, they are not required to stop. Legally speaking, maybe ethically, but not legally speaking. They're not required to, unless they were working at a hospital. They have to. The drowning person example, I am not required to help, but a lifeguard is, right? So the failure to act, nonfeasance, only attracts liability if the law determines, if it determines based on your capacity. As a parent, as a father, the law requires me to take care of my children. If I fail to take care of my children, then my nonfeasance will attract liability too. Does it make sense? Let me also point out one thing that you may use for life. We are not required to save someone that is drowning. But if we decide to, okay, I know how to save, so I will try. And if by trying to save someone drowning, I cause them more injury, then I will be liable to that injury I have caused. Because as soon as I started, I have to act within the standard of care. If I act below the standard of care, then I am liable. Okay, the same thing for the doctor. For a doctor who's on the road, they stopped to help someone who suffered an accident. They were not required to, but they wanted to. If they acted in a way that caused more injury, more harm, they may be liable for their conduct. So that's misfeasance and nonfeasance. Well, now let's talk about causation and damage. They are related. Why related? Well, first of all, as I told you initially, no injury or no loss or no damage, no negligence claim. So here what I'm saying is, on the top of the examples I've given you already, what I'm saying is my daughter plays the basketball at the neighbor's window. A duty of care is owned. She breached the duty, but the window is not broken. No damage, no negligence claim. If the window is broken, then there may be a successful negligence claim. So damage, loss, injury, they are required. But when there's this damage, injury, or loss, this has to be direct linked with the wrongful conduct, with the conduct that was below the standard of care. Does it make sense? This is causation. Again, I asked everyone to leave the classroom. I'm fixing the projector here. Someone walking on the hallway, they sue me because they allegedly say I caused them an injury. This wouldn't be directly related to them. This is too remote. This is too far, right? So causation is related to the direct consequence of the wrongful conduct. Does it make sense? All right. And there's also the remotedness test. Well, the example I gave you about the person in the hallway. Another example is I was driving, I lost control. I was actually texting and driving, lost control, hit a light post. Light post went down, no electricity in the block, around the block. One of the businesses in the block, they were a coffee shop. There were clients who would come to the coffee shop. Clients could not come. The business suffered a loss. This is too remote for me as a wrongdoer. By hitting the light post or by driving, it is foreseeable that I may cause loss to property, but not loss of revenue to business that may be located in the block I may hit. So it's too far. So there's this limitation. Because if there were not such a limitation, I would then be liable to the coffee shop, and then the clients who didn't come to the coffee shop, they had a meeting to close a deal, I would also be liable to them, and then, so it would never stop. Okay, so it has to be with close relationship. It won't go far away. Two other rules that are important: the Thames-Go rule and the Crumblings-Go rule. So the Thames-Go rule says the victim is taken as they are. Well, the victim is taken as they are means if I have weakened bones, let's say I have osteoporosis. Have you heard about this? This illness, osteoporosis, when you have weakened bones, you get fractures or they are broken more easily because they are weak. So let's say someone hits me. Because I have osteoporosis, most likely I will have more bones broken as compared to a healthier person who would be hit. Does it make sense? So the person who hits me, because of the thin screw rule, they cannot claim as a defense that because I had osteoporosis, I had 20 bones broken as opposed to only 2 for a healthy person. Bad luck for the wrongdoer. The victims, they are taken as they are. Because I had osteoporosis, I have to be compensated fully for all my 20 broken bones. Right? The crumbling screw rule is a limitation to the thin screw rule. Because yes, I have to be compensated to the full extent of my injury. But I don't need to be compensated for my precondition. So in my compensation is for my 20 broken bones, but not for the cure or healing of osteoporosis, because osteoporosis was already a precondition. That has nothing to do with the guy or person hitting. Does it make sense to you? So limitation. Here, thin screw rule, victims are taken as they are. Crumbling screw rule, they don't need to be put in a better position than they were before the accident. Okay? All right, so that's what negligence is. And as I said, one of the most important torts we have, the most common torts we have. Whenever we suffer a loss, the question is, what was a duty owned by the wrongdoer? If the answer is yes, did they breach their duty? If the answer is yes, was the damage directly related to their conduct, their wrongful conduct? The answer is yes, most likely successful negligence. Okay? If you are ever sued for a negligence claim, you may have one of 3 defenses. I'll focus first on the most common one, contributory negligence. Again, pay attention to the wording. The wording may help you remember. Contributory comes from contribution. So when the plaintiff suing, when the plaintiff, who is the victim, when they also contribute to their own loss. Yes, they suffered a loss. The defendant, yes, acted negligently against them, but the extent of their loss was contributed by them. Best example you have in your textbook. So those guys were, they registered for this tubing competition in a ski resort. After they registered, they started drinking. And they went through the first round. They got a small accident. They were involved in a small accident, small injury. During the break from the first to the second round, they kept on drinking. The ski resort was aware. In the second round, one of them suffered a serious accident that rendered him quadriplegic. So they sued for negligence. They were successful. However, the court said that they also contributed to their own loss. So when contributory negligence is successful as a defense, compensation is still there, but not to the full limit. Compensation is limited. So the judge will apportion the loss. So if I'm not mistaken, in this case, he was compensated with $100,000, maybe more. But my example here is, let's say, if compensation for the negligence tort was $10,000 and contributory negligence was a valid defense, the judge would say, hey, you would be awarded $10,000, but because you contributed to your own loss, you will be awarded only $8,000, only $5,000. Well, whatever the proportion is will vary from a case-by-case basis. It can be 50-50, 80-20, 10-90. So that's contributory negligence. So in most negligence lawsuits, the defendants, they will say, okay, judge, yes, I had a duty of care, I breached that duty, and the damage was caused because of the breach of that duty. However, the defendant, they also contributed to the loss. They were speeding, they were texting and driving, and there's evidence for this. They crossed the red light or they were drunk. So they did something that caused the extent of their damage to be higher. So they have to bear some of their loss. Are we good? So that's what contributory negligence is. We have two other defenses: voluntary assumption of risk. This defense is usually not so successful. Why? Because courts, they understand that someone may voluntarily assume their physical risk, physical body, but not their legal risk. Courts understand that people in general, they don't know what their legal risks are. And a legal risk is the possibility to sue or not. So if I assume my legal risks, it means I'm waiving my rights. And courts understand that usually people don't do this. So the example here would be, last Saturday, I was at a party with a friend. I drank a lot. My friend didn't drink. I was drunk. My friend got a ride with me back home. And my friend knew I was drunk. And then I suffered an accident. I caused an accident, caused my friend an injury. My friend is now suing me. So in my defense, I'm telling the court, hey, court, my friend knew I was drunk. So they voluntarily assumed their risk by taking the ride with me. But courts will say, no, 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 it doesn't work like this. They may have assumed their physical risk, but not their legal risks. So you have to compensate them. Okay? Ski resorts, amusement parks, they usually try to rely on this voluntary assumption of risk. How do they try to make this work for them? They usually make us, when you buy your ski ticket, snowboard ticket, do you have to sign something before? A waiver. So waiver, it's like a contract, but in a waiver, you are telling the resort that if you are injured or if someone else injures you, you are waiving your right to sue the ski resort. So you are saying to the resort that you are voluntarily assuming all your risks, right? So they try to make this defense available if needed, but not always will that work for ski resorts, even for ski resorts or amusement parks. What they usually do, they have big capital letters. They make you sign. Nowadays, I remember last year I went snowshoeing and I purchased my ticket, and 1 or 2 days later, before going to the resort, I got an email saying, hey, if you want to get ready for your snowshoeing, you may want to read and sign and acknowledge, etc., the waiver, even before coming. So they try to inform me as clearly as possible, as advanced as possible, because this is one of the good practices that will help this defense to work well in court. But not always this works. It depends on the situation. The consequence is that, or the conclusion is that courts, they are much more protective of the victims rather than, in this case, businesses. Because the ski resort is making money. So at some extent, they need to bear liability for injuries, etc., at their premises. But that's how it is. And another is illegality. So illegality is also rarely successful. But the example here is if you are acting illegally and you suffer a damage or an injury, you cannot sue to recover because you were acting illegally. So let's say I was driving When I was 16, I had no driver's license at that time. So I was an illegal driver and I suffered an accident. If this defense were successful, the other driver would not pay any compensation to me. But courts usually say, no. Okay, I was an illegal driver. What they usually do, they apply contributory negligence. So they reduce my compensation because I contributed to some extent, but they do not accept illegality. Because with illegality, the defendant would get away completely from their liability. And courts do not like this much. There's a situation that I'd like to bring to class that sometimes works like this. And it's even clear in the law in BC. So if there's a trespasser to a property and they get injured and they sue the owner of the house, can the owner of the house raise illegality as a defense? Yes, they can. I think I mentioned on Wednesday. For break-ins, trespassers, illegality will work. Unless the owner of the house willfully, deliberately caused the trespasser or the robber to be injured. Okay, so that would work there. So take a look at this case. Give it 1 or 2 minutes. What would your response be here?
It does not matter who, like it would have been someone else as well, but still he hurt her.
Okay.
It's his duty to be careful because he's the one on high speed.
Okay, so you are saying that Harry's defense would not be successful.
Yeah.
Okay.
Irrelevant to the actual negligent action.
Okay.
Because he is the one who was on higher speed.
Okay. Yeah, does make sense. Let's just look at this together. So Joe was struck by Harry. So let's look at the 4 requirements for a negligent tort. Harry, did Harry owe a duty of care to Joe? As a skater, do you owe a duty of care to others, pedestrians, people?
Yeah.
Yes. So answer for the first question, yes. Did Harry breach his duty of care? Yes, because he hit someone else, right? When you are riding a skate, you wouldn't hit anyone or any property, but he hit Joe. Okay, so yes, the duty of care was breached. Was there damage or injury? Yes, crushed his hand. All right. So is this clear? Is it clear that a negligence tort here would be successful? All right. So now Harry is trying to defend himself, saying that, well, I didn't know Joe was a concert pianist. So it's because I didn't know. It's not fair that I have to compensate Joe as a concert pianist. I should compensate Joe as a regular person. And you're saying that this defense is not valid. And you're right. Why? What did we see that tells you that this defense is not right?
It doesn't matter what the condition of the
Victim?
person who got hit is, but they have to still compensate fully.
Yeah. Victims are taken as they are, as they were. So because of the thin school rule, Harry's defense will not be successful. Does it make sense? If there were a skate pathways, or a pathway specifically for skateboarders, and Joe was walking in that pathway, there would still be the negligence tort. Joe would still be compensated as a concerned pianist, but probably the judge would apply contributory negligence, because Joe, to some extent, contributed to his own loss by walking or being in the skate pathway. Does it make sense? Yes. That's how it works. Very good. So now let's look at some types of liabilities. As I said, there may be occupier, product, strict, professional, etc. So the first one is occupier's liability. Well, first of all, let's keep in mind that occupier's liability was created by legislation, by an act, by a provincial act. So in BC, there's the Occupiers Liability Act. There may be Occupiers Liability Acts in other provinces, but I don't know this in detail. But in BC, there's one. And the Occupiers Liability Act says that whoever occupies a property, they are liable for injuries, damages, losses caused to visitors, to people who are in. So let's say I rented this room. I rented this room for this lecture. If any of you is injured or suffer a loss, I am liable. Not the owner of the room, the owner of the premises, but the tenant, the one who's occupying. That's what occupier's liability says. Like in my house, my apartment, when my daughter invites one of her friends to come over, if her friend is injured, I may be liable because of occupier's liability. So if you are in the event industry and you rent places to promote or to make events, you are usually required to purchase insurance because occupier's liability applies to you or may apply to you. Is this clear? So it's usually related to the condition of the premises. So let's say my daughter's friend was going up the stairs fell, and she was injured. Could be activities they were doing in our apartment. They were jumping, playing, jumping out of the sofa or bed, or could even be the conduct of third parties. So let's say there's someone delivering something in my apartment. They enter the apartment and they cause an injury. I am also liable. Or third party could be in a company. So in a business, you have a supplier coming to do some work, could be maintenance or installation at your company. And if they cause any injury or losses to one of your employees or visitors, you may be liable based on occupier's liability. Are we good?
How about a hotel? You stay in a hotel and you get it.
Innkeeper's liability, which applies the same concepts of occupier's liability. Yes, if you're at a hotel, management of the hotel, they will be liable. Not only if you are injured, but also if your goods are damaged, stolen, lost, they are liable. Because they are making money out of managing the property. So they are liable. They usually carry liability insurance. Okay? Okay, so you anticipated my slide. Yes. So, yeah, occupiers liability, innkeepers, similar concepts. Now, strict liability. You have a question? Yes.
What if I lose my laptop here or if it gets stolen on BCIT ground?
Okay.
That
Well, if it gets stolen, yes, BCAT could be liable to compensate, but I'm saying could be because it depends on the event. So did you leave it unaccompanied, or were you promised that you could leave because I would lock the door? But so it depends also on how you acted. It's not necessarily BCAT's liability, but it may be. If I promise as BCAT's representative, instructor, if I say, hey, you can keep everything in classroom, during the break, I'm gonna lock the doors, then I'm guaranteeing BCAT could be liable. Okay? So now with strict liability, what is it? This is liability when there is no fault. Well, strict liability, actually, you already know. Why you already know? Because vicarious liability is one type of strict liability. So remember, vicarious liability, the employer not at fault, they are vicariously liable for the wrongful conduct of the employee. When does strict liability apply? It applies when the activity or the goods, they are inherently dangerous. For example, I have explosives here in my backpack. It's just an example, it's not for real. Okay? But let's say I have explosives here. Would you agree that explosives are inherently dangerous? So what I'm saying here is that if there's damage caused or loss or injury because of the explosives, regardless if I was at fault, meaning regardless if I didn't pack it properly, if I didn't put signs, regardless of my fault, if they cause losses, I am liable. So with inherently dangerous goods or inherently dangerous activities, you, the victim, you don't need to prove fault from the wrongdoer. You just need to prove damage and causation. Well, the damage was related to those goods or services or activities. Then you will be compensated. Is this clear? Another example would be, let's say you have chemicals in your garage. Chemicals, inherently dangerous. You pack them properly, you store them properly, there are signs, but they leak and go to the neighbor's property and cause damage to the neighbor. All the neighbor needs to do to be compensated by you is to prove they suffer damages based on chemicals that leaked from your property. That's all. They don't need to prove that you were negligent, you were careless. No, they don't, because it's no fault. Fault is not required. Okay, you have a question?
What happened in this situation when you park your car in the parking, public parking, and someone leave the fuel, and that fuel cause your car to burn, and your car start to burn other cars. Who's liable?
Well, initially was the one who gave cause to the fire. So it was the first car. Or if the car just spilled.
Someone just spilled the fuel in the ground, and someone lit the
something
cigarette.
like a wildfire.
Okay, so in this case, it's both the person who did it and the parking lot administrator. Because they also have a duty to manage and to protect, mainly when they are charging for parking.
How you can prove it that things make your car burn and make a damage to another's cars.
Well, in this case, you need expert evidence. You need expert witnesses. You may need recording. You may need scientific evidence. You cannot just claim. You may need witnesses. You may need recordings. You may need evidence that one car was burned, not because it burned itself, but because it was fire from another car. And forensics, scientific methodologies, they usually help prove those events. So you're going actually to the core of whoever started that, and also whoever was at fault, who should have managed or taken care of that property. Okay, but it may be the case that your car caused my car to be burned. I will sue you. But if you were not the one who caused the fire to your car, well, you may have to pay compensation to me. However, you may go after whoever caused the fire to you. Okay, so there may be multiple or more than one lawsuits. Okay. Yeah, this is not legal advice. This is okay. Just thinking about an example. All right, so before product liability, let's take a break. Let's make it 2:40. 12 minutes, is this okay? Yeah, 2:40, we're back. So let's resume. Now we look at liability that is related to a product. So if a product causes losses, damages, or injury, the manufacturer may be liable. So that's product liability. If we sue the manufacturer, if we sue under product liability, we have to prove the 4 required elements. What are the 4 required elements? Remember? Duty of care, breach of the duty, causation, and the damage. Yes. So if you're suing a manufacturer, you would prove all this. Can you give me an example of lawsuits against manufacturers? I think we discussed one of
the battery explosions.
which one?
Samsung S7.
Yeah, Samsung 7. So we discussed class actions. So a class action, the class action against Samsung, or the car manufacturers when they make a recall because one of the parts has an issue, not functioning or is broken. So they may be sued under product liability. Can you sue under contract? If you buy, not the drink, but let's say the laptop, the tablet. So you purchase the tablet. The tablet is not functioning well. Can you sue the seller under contract?
Yes.
In principle, yes. Because the seller may have breached the contract. They delivered you a product that is below the standard. So when we buy something, we may be able to sue under contract. But we may also be able to sue the manufacturer. But when we sue the manufacturer, do we sue under contract? No, you sue under product liability, under tort. Because you didn't buy from the manufacturer, you bought from the seller. So you may sue the seller under contract or sue the manufacturer under product liability. Another situation is let's say you went to Tim Hortons now during the break. You brought coffee to me. So you purchased coffee and you gave it to me. The coffee made me sick. So I may have lost wages, medical bills, etc. Can I sue Tim Hortons under contract? Why not?
Because I was the one who brought you this.
You were the one buying the coffee, so you were in a contract. I was not. But do I not have any remedies?
For the client.
Exactly. In this case, I would sue Tim Hortons under product liability because I was sick based on their product. They prepared the product, they prepared the coffee. Okay, so product liability is used when a product, when goods, they cause damage, loss to us. Now, liability of professionals. Professionals of all types. Could be a business consultant, could be a gardener, could be a plumber, could be a lawyer, an accountant, dentist, doctor, all types of professionals, could be a lecturer. So professionals, when they are performing their duties, delivering their services, they may make mistakes. They may make unintentional mistakes. What if an accountant makes a mistake while preparing a financial statement? And then the client relied on the financial statement to make a decision. The client then suffers a loss. The accountant may be liable. What if the lawyer misses a deadline and because of this the client cannot proceed in a litigation? The client may suffer loss. Doctors malpractice. Those situations are usually out of careless conduct, inadvertent conduct, not on purpose. But still, they may cause losses to others. So professionals are liable. And professionals, when they are liable, their standard is higher. Professionals are held to a higher standard. Well, if you have a legal doubt, who may offer you better advice? A friend who is taking this below course or a lawyer? A lawyer. So the lawyer must be held to a higher standard because they are more knowledgeable. They are theoretically prepared to give you advice. Doctor the same, dentist, pharmacist, all types of professionals. So they are held to a higher standard. And what if a lawyer or any professional causes a client a loss? They will be compared to the standard of another similar professional. Right? So those are things we should keep in mind. What else? Inexperience. Inexperience by a professional is not a valid defense. So you know I am not a Canadian lawyer yet. So when I become a Canadian lawyer, let's say my first case is a complex one. I take the case, but because of mistake, inexperience, I cause my client a loss. They sue me for compensation and I say, hey, I wasn't experienced. This is not a valid defense. Because we know this is not a valid defense, what should we do? What should I have done? Sorry?
You should take the case.
I shouldn't take the case. I should deny the case. That's right. Sorry, I cannot take it. I'm still inexperienced for such a complex issue. Or sign a document.
And we can lose this case.
Maybe. this is still not valid because I'm asking the client to accept I am inexperienced and that any losses that I cause, he may bear. This wouldn't help. Well, what would you do if you are inexperienced, but you want to take on the challenge? What can you do?
So, don't charge fees.
Okay, but even if you don't charge, you may still cause loss. Exactly. You can partner with someone who has more experience. Could be a partner lawyer, could be another lawyer can help you, can mentor you. And this is an example for a lawyer. It could be for an accountant, the same thing. For a junior accountant, get a more experienced accountant who can mentor them, who can help them. So those are things we know. And when we think about this course, remember I told you, first lecture, when we think about it as a legal risk perspective, those are the type of questions you have to make yourself. Okay, I know where the risk lies. So what should I do? What can I do to avoid the legal risks? How can I better address the risks I may face? Right? So those are questions you should make yourself. Professionals or experts, they have a fiduciary duty. What is a fiduciary duty? This is an enhanced duty. This is a duty that requires the professional to act with loyalty and good faith with their clients, to act only in the best interest of the client. And if I don't act as such, I am breaching the trust or the fiduciary duty. This may also attract liability. So my client comes to me and says, hey, João, I have a secret. I want to keep this as a secret, but I need to discuss about the secret with an expert, with a scientist. And then the client reveals the secret to me. Because of the fiduciary duty, I cannot use the secret to my own advantage. Nor can I share this with others that could take some advantage out of it. This would, again, attract liability. This would be a breach of the fiduciary duty. Question for you. B, Bob?
Yep.
Exercise skill with degree of care expected from a reasonable person in that profession. Exactly. That's what a reasonable person is for a profession. So they are held to this higher standard, the standard of their profession. Very good. Any doubts or questions in any other alternatives here? No? E, the standard of an expert need to be perfection. No, no one is required to be perfect. Perfection is not required from anyone. Does it make sense? It's, how can the law require someone to be perfect? They have to be held to the level of their profession, higher standard than a regular person, but not perfection. No one can be required to be perfect. And actually, no one is perfect. Okay, that would be a too high duty. And what would perfection be? how can we define perfection, right? So it wouldn't be possible. All right, so we talked about negligence. We talked about occupier's liability, innkeeper's liability, product liability, strict liability, professional and experts liability. How can we mitigate this risk of being liable? We cannot eliminate, because the law says there is liability if damage loss is caused. But how can we mitigate?
Give them all the options. The results which may come out of a practice. Like, we cannot assure a bail for some person, but we can tell them that it's possible that you will not get a bail if we go with this procedure.
Okay, so in this case, you are not committing to
I'm not
a
committing-
result.
Yeah.
You are committing to your best expertise, your best experience. But even when you commit to your best experience, knowledge, you may still make mistake. So there's a mechanism, there's a product that helps mitigate this liability. And this is known as insurance. So as a business owner, because you know you're vicariously liable for the wrongful conduct committed by your employees in the course of employment, you should have liability insurance. Actually, for some professionals, for some professions, a liability insurance is required. This is the case for a lawyer in BC. A law graduate after articling, after the course, before they are called to the bar, they need to show proof of liability insurance. And other professions as well, not, I don't know all, but I know for sure for lawyers.
Shipment companies to have insurance.
Shipment companies, yes. And any company can buy insurance. Yes, it's cost, but it's a way to avoid having to pay the full amount of compensation. So there's professional insurance that will cover negligent conduct. Professional insurance will not cover fraud or breach of trust. If I act fraudulently as a lawyer, my liability insurance does not offer coverage. But if I make a mistake, I forgot, I missed a deadline for my client. My client is now facing losses. They may sue me. I'll make a claim to my insurance. Right? So what is insurance? Well, insurance is the client, the insured. They are transferring the risk, their risk, to the insurance company. And by transferring their risk, they pay a price. This price is known as premium. So if you have a car, you know the car insurance, you pay a premium, yearly premium. Any losses you suffer with the car, you may file a claim and you will be compensated. But it may be the case that for a given year, you pay the premium, but you had no claims. This is also good news, because even though you not wasted, but you lost the money for the premium, but when we make claims, the next year our premium will go up. So we usually say that a good insurance is the one that we never need to use. We know we have just in case, but we don't want to use it. Right? That's what insurance is the transfer of risk from ourselves to the insurance company. You know that insurance industry, they are very powerful. In the world, we have the pharmaceutical companies, very powerful. Insurance companies, very powerful as well. And I'm talking about the legal ones. The illegal ones, the drug cartels, weapon trafficking, human trafficking, they are also very powerful, unfortunately. But because of this industry power, they are tightly regulated. There's a lot of laws, legislation for insurance. Because they are so powerful that they try as much as they can to avoid paying coverage to the clients. They try to limit their exposure. So legislation is there, usually, not always, but usually, to protect the insured, the clients. Okay? So parties in the insurance industry will be the agent that works for the insurance company. When you buy insurance, car insurance, ICBC insurance, you talk to an ICBC agent, but could also be an insurance broker. The broker is the one who has an independent business, and they represent several insurance companies. Both the agents and the broker, they have a duty of good faith to the customer. So duty of good faith is to disclose all pertinent information, not to lie, not to mislead, not to deceive. And we have the insurance adjuster. So the insurance adjuster is the one that will assess the damage you suffered, the loss you suffered, and will come up with the amount you will be compensated. So based on your car accident and based on the damage caused to your car, they will pay $5,000. Since 2021 in BC, the law does not allow insured, the clients, to sue ICBC if they disagree with the insurance adjuster's assessment. All you can do is to appeal within ICBC, but it's still within ICBC. If you think more critically, this new method, this new way, may be a violation of our charter rights, because we have access to justice as a fundamental right. By the way, there's already a lawsuit against this prohibition to sue ICBC, challenging this, but there hasn't been a decision yet. But nowadays, today, if you suffered an accident, let's say you will need to go through physiotherapy, you will develop any mental anguish, depression, anxiety, etc. The adjuster will say, okay, 100,000. But if you deserve more, you cannot go to court. Before 2021, you could. Actually, many of the lawsuits against ICBC were because of the adjuster's job. Now you cannot. Okay. Right, so let's look at some types of insurance. First one, liability insurance. Well, this insurance will cover damages that are caused by negligence. Again, it will not cover deliberate, willful, fraudulent acts. And insurance will be available when the insured, the client, is at fault. So you gotta be at fault. ICBC insurance now, since 2021, they are a no-fault insurance. Regardless if you were at fault or not, they will cover. And in ICBC, the government, they are claiming it's a better system for everyone. I am not advocating here, not for, not against. I'm just saying how it is. For a liability insurance, if you were at fault, you caused the loss, you were negligent, then you can make a claim to your insurance company. If it was someone else that was at fault, they have to make a claim to their insurance. Okay, because it was their fault. Property insurance, so losses to buildings. And it could also be that not only to buildings, but you can pay a higher premium for also appliances, for any other valuables you have at home, anything else you want to insure. But the more you add to protection, the higher your premium will be. And if you are a tenant in BC, there's tenants insurance. There's homeowners insurance. So they will protect any issues or losses related to the buildings. What else? Business interruption insurance. Well, as the name says, if your business is interrupted, flooding, fire, an accident, so you cannot operate your business, and then you have costs, you have to pay rent, you may have to pay utility bills. Well, you will be covered by all those costs, plus the income you would have made, or an estimate of your income. Okay, so that's the business interruption one. Lost profits and the expenses. So that you're back in business. Life and health insurance. Well, life insurance. Does the client get the coverage of life insurance? No. I know it is obvious, but it's important to put this obvious in words. A life insured does not get the coverage. It is their beneficiaries. And their beneficiaries are not part of the contract. It is the life insured that purchases the insurance. However, the law protects the beneficiaries. And I'll tell you what this protection is when we go through contract law. Okay, so just keep that in mind. Life insurance, the coverage is paid after the death of the insured. Here, with regards to bonding, let me talk about surety bond. Surety bond is not actually an insurance, but it is a protection, monetary protection that a party purchases in case they do not finish a job or they do not finish the job on time. Surety bond is used a lot with big projects, usually public projects. So the government, when they put out a public bid or tender, they usually require the bidders, the companies that will make their bids, to add surety bond. In other words, the government is saying, hey, if you win the public bid, you need to complete the job. And you need to complete on time. If you miss to complete or to complete on time, we want to be compensated. And our guarantee we will be compensated is in the surety bond. Your words, the agreement, doesn't matter for us. We need surety bond. It's not actually an insurance, but it's a product. It's a protection product that is offered by insurance companies. Now, the concept of insurable interest. Insurable interest, so it is an interest that can be insured. So insurable interest means I can only buy insurance if I am the one suffering the loss. Your car. If there's a loss in your car, who suffers the loss? You or me? It's you. So I cannot buy insurance to your car because I have no insurable interest to your car. You have. I have no insurable interest to my daughter's car. She has to buy insurance to her car. I can pay for her because she doesn't work, so I can pay. But she's the one buying. She's the one suffering the loss. So for us to have an insurance, we need to have insurable interest. Okay? When I am a tenant, Do I have an insurable interest in the property I'm living in? Yes, I do. If there's leaking, water leaking, if there's fire, if I forget something on the stove, I may suffer the loss because I may cause loss to other neighbors as well. So I do have an insurable interest. Now, because the insurance industry is so powerful, courts have come with this contra preferentum rule. What does this mean? It means that if an insurance contract has ambiguities, courts will interpret those ambiguities in favor of the client, not the insurance company. Because it was the insurance company who drafted the agreement. So they cannot be favored by any ambiguities they came up with. And when there are issues with regards to the interpretation of coverage, courts, they will interpret coverage broadly. And they will interpret exclusions of coverage narrowly. Again, favoring the client, not the insurance company who drafted. So this is based on the contra preferentum rule. Duties of the parties in an insurance contract. So they insure the client, they must disclose all pertinent information. For a life insurance, if they ask you if any of your family members has had cancer, you have to say the truth. If you lie, and then if you die from cancer, they may deny coverage. They usually ask about diabetes, heart problems. Yeah. So whatever questions they make, even for car insurance, my ICBC car insurance, he asked me, do you use your car to work? Is your work further than 15 kilometers? Do you park your car in a covered garage at night? So all those questions, because it's an insurance contract, we clients, we have a duty to say the truth. Because again, it's part of the insurance business. They try to limit coverage as much as they can. And they can limit if we lie. Okay? The company, the insurers, they have to process our claims fairly, and they have also to offer us legal representation. So if I have a professional liability insurance as a lawyer, and if I'm sued by a client, I will make a claim to my insurance so that my insurance offers me legal representation and defense. They will deal with it. Now, subrogation. What does this mean? It means that once the client, the insured, is paid out the coverage, the insurance company steps into their shoe. So let's say ICBC, they are a no-fault insurance, at no-fault insurance now. So let's say I suffered a loss, but it was hit and run. I don't know who hit me, so I make a claim to ICBC, they pay out. And then they now have the right to sue the other driver if they find out who it was. I don't have the right anymore because I was already compensated by that loss. And this is based on the subrogation principle. So based on subrogation, I cannot be benefited twice. Once the insurance company pays out coverage, they retain the rights to go after the party that was at fault. And another principle is the right of salvage. right of salvage is, so I suffered a car accident. ICBC decided to compensate me for loss of car loss. Car was fully lost. So they pay me the full coverage. Now that damaged car belongs to ICBC. They will do with the damaged car whatever they want to. They may want to sell the pieces. They may want to recover the car. And how do they call when it's a recovered accident car? Is it rebuilt? Rebuilt, yeah. So they may have the car fixed and sell as rebuilt or whatever, it belongs to them. The same thing is, let's say, there's an Amazon truck coming from Washington State to BC, and they suffer an accident. All their goods are insured, so they make a claim to the insurance company. Amazon is compensated, but now the damaged goods belong to the insurance company. They may throw them away, they may donate, they may sell with a discount. They will do whatever they want based on the right of salvage. Okay. All right. So we talked about negligence, several types of liability, and ways to mitigate that risk, that financial risk, which is basically insurance, the several types of insurance we can have. Questions, comments?